God save the United States and this honorable court. The first case is Emily Young versus the United States. Please be seated.
We welcome everyone to the Jenkins Moot Court competition. We will call the court has, you have called the case, so we're ready for the first appellant. Counsel for the first appellant.
Good evening, Chief Justice, and may it please the court. My name is Matthew Hall, and in my time before the court, I will represent the petitioner and will be addressing the first issue and will explain that Miranda warnings apply when a person is subject to custodial border interrogation, and that introducing pre-Miranda silence as substantive evidence of guilt at trial violates the Fifth Amendment by effectively compelling that person to testify. My co-counsel Nicholas Sepnick will address the second issue and will explain that the amended sentencing guidelines violate the ex post facto clause. At this time, petitioners are asked to reserve 2 minutes for rebuttal.
That's fine.
Thank you, Your Honor. With regards to the Miranda and Fifth Amendment issue, petitioners respectfully urge this court to reverse the 14th Circuit's decision for 3 reasons. First, petitioner was in custody. Second, petitioner was subject to the functional equivalent of interrogation. And finally, introducing Ms. Young's silence at trial violates her Fifth Amendment right by effectively compelling her to testify. Turning to my first point, this court has held that Miranda warnings apply to custodial interrogation. As this court noted in Thompson v. Cohane and Minnesota v. Murphy, an individual is in custody if they are restrained to a degree normally associated with formal arrest. This standard, importantly, does not require a formal arrest.
Now, she subjected herself to this, remember. She presented herself at the border and asked for admission. This is not a situation where someone was walking along the street and a police officer stopped him. This is something to which she voluntarily subjected herself. How are we going to describe that as custody in the normal sense?
Your Honor, the custody determination is a fact-intensive study, even if a person voluntarily submits to crossing a border. This court has held that the determination of custody is, in all instances, a determination of the facts of the case. So in this instance, whether she voluntarily submitted to the border stop or not is just simply one factor in the total analysis.
So it doesn't change, in your view, it doesn't alter the problem, though. The fact, now, could she simply have turned around and left?
No, Your Honor. This is an important consideration in the custody analysis, that at no time, once she approached the initial stop, she was not free to leave. Indeed, it would most likely be a crime to leave the stop of a border search without first being dismissed by an officer. This court has held that the custody...
Do you have anything you can cite for that?
No, Your Honor, but in this case, this is most similar to a traffic stop, where the initial stop, if a person leaves the scene of a traffic stop, it is indeed a crime to leave the scene of a traffic stop without first being dismissed. This court has held that the custody analysis analyzes whether a reasonable person would have believed that the constraint on their movement was to a degree normally associated with formal arrest. Here, a reasonable person in Ms. Young's situation certainly would have believed that she was restrained to a degree normally associated with the formal arrest. Border stops are intimidating places, especially in the post-9/11 environment. As a result, people are nervous when they approach the border, and rightfully so. When they approach the border, they're met by a large number of officers. Many, if not most, have weapons. Many have police dogs in tow. There are gates, signs, lights. The environment surrounding a border stop simply puts people on edge. People are jumpy. The fact remains that people are intimidated, if not afraid of, police officers. Indeed, this is one of the concerns that drove the Miranda Court to draft the now famous Miranda warnings. People are afraid around officers.
Well, Is it your position then that she should have been given Miranda warnings right the minute she was approached by one of the Border Patrol agents?
No, Your Honor. At the initial stop, when she first approached the border, this is indeed not custody. Finding custody in such a situation would be unreasonable.
Well, when is it your view then that custody began?
Your Honor, custody began after she answered the question, the general purpose of the visit, and the normal, regular investigatory questions had finished. It's important to remember in answering your question, Your Honor, that when people approach a border, they have certain expectations. A person expects to approach the border, hand out their their passport, license, registration, answer a general purpose of the visit question, perhaps one or two other questions, and then they expect to be dismissed. Here, Ms. Young was not dismissed, and as a result, people get nervous when this happens.
So that's the test then? Custody begins when they get nervous?
Not necessarily, Your Honor. The custody determination is when a reasonable person would have felt that they were functionally under arrest. And nerves are certainly not the only factor. But when a person believes that something is amiss, here...
When you say would have felt under arrest, usually there are certain aspects of that you look at to see what constitutes... We usually talk, were you free to leave? Could you just turn around and leave? Clearly, if you're right, you can't turn around when you get to the border and say, I think I'll stay in Mexico today or wherever you are. I'm not sure of that. But what you're saying is as soon as a person feels that it would be uncomfortable or difficult to leave the situation, that person is in custody so that anything she might say would be compelled?
Your Honor, perhaps I misspoke. The determination of custody is not necessarily based on nerves or when someone feels uncomfortable. These are factors to consider. Another factor is whether a person is free to leave, whether an encounter ends in arrest, and many other factors that this Court has analyzed. So while Ms. Young certainly would have felt uneasy and nervous that something was wrong, it is in this instance that a reasonable person would have felt that they were restrained to a degree that's normally associated with a formal arrest. Here she could not leave, and indeed she was ordered to move to a secondary inspection area. Here, certainly, a reasonable person would have felt that this constraint on movement was to a degree of formal arrest. The standard that this Court has announced does not analyze whether a reasonable law professor, whether a reasonable constitutional scholar, well-versed in their rights, would believe that they were subject to a formal arrest. This standard analyzes whether a reasonable person, people who have never read a case, people who've never read a law review article, indeed have most likely never read the Constitution, what these people would believe. This, a reasonable person in Ms. Young's position, would have believed that they were functionally under arrest, that their movement was restrained to a degree associated with formal arrest. As this Court has established, this is all that is necessary for a finding of custody.
So you're saying essentially that whenever you have an encounter with a law enforcement officer, whether at the border or maybe at a sobriety checkpoint or something like that, that anything that you might respond, anything you might say other than just answering questions is considered compelled so that it could not be introduced in trial to impeach your testimony or a substantive testimony?
Your Honor, in answering your questions, it's important to remember that there are differences between questions asked at a sobriety checkpoint or even general investigatory questions at a border stop. Statements are not necessarily compelled until a person is held in custody and asked to respond to an official question, or they feel asked to respond to an official question. This Court addressed the sobriety test and a traffic stop situation in Terry v. Ohio. The Court held that a reasonable traffic stop does not equate formal custody, and that even questions asked at a sobriety checkpoint do not raise the level of interrogation. The Court held that in that instance, Miranda warnings were not required. But this case is fundamentally different than a routine traffic stop, and the questions posed and the situation at issue is likewise fundamentally different.
what were the questions that you're saying were so fundamentally different? That's my first question. And the second question is, you referred to this as a custodial border interrogation, and looking at the reasonable person standard. Is that not a subjective standard? And how are we to decide those kinds of situations when there really doesn't appear to be any objective grounds for determining when a person is in custody according to your definition? Sorry for giving you two questions. That was not fair, but
That's okay. I will address your question in two parts. Here, Officer Hale spoke to the petitioner 5 times. The first statement was, "What is the purpose of your visit?" This statement is not problematic. Officer Hale then asked petitioner to roll down her window, or more precisely, to move a baby screen away from the window. At this point, he noticed the number of piñatas inside of the back seat and exclaimed, "Wow, that's a lot of piñatas." He then asked petitioner to move to a secondary inspection area. Then Officer Hale asked petitioner at the secondary inspection area, after a further inspection, to step out of the car to be placed under arrest. It is the statement, "Wow, that's a lot of piñatas," that is the problematic statement.
Well, it's good that you're focusing on the officer's statement, but this is a case about her silence. And why is it that we're talking about her statements when what we really should be talking about is her demeanor, which is perfectly acceptable evidence? There's no constitutional prohibition on demeanor evidence.
Your Honor, the statements in this situation are important because they are relevant for whether petitioner was entitled to Miranda warnings once the stop continued on when a reasonable person would have believed it would have. Therefore, the statements are not necessarily relevant to a determination of the Fifth Amendment violation in this case, but this court must analyze whether a reasonable person felt they were under arrest and whether they were functionally interrogated at the scene to analyze whether Miranda warnings were required.
So your view is that certainly at the point at which she was told to go to secondary, that she should have been given Miranda warnings?
Absolutely, Your Honor.
Well, that would certainly alter dramatically the practice on the U.S. border. That simply doesn't happen. Take it from a judge who's seen a few thousand border stops. It doesn't happen. So you're asking this court to hold for this country that once they go to secondary, which happens regularly, that they have to give Miranda warnings. And you're doing it in a case where your client said nothing.
Your Honor, I appreciate that many...
Hard sell, counsel.
Do you need to get to the Miranda question?
He seems to be headed there.
I know.
Look like it.
Your Honor, even if...
In order to get to the result you want, which is to keep the fact of her silence out of the trial.
Not necessarily, Your Honor. Even if this court finds that Miranda warnings were not required in this instance, the silence can still be excluded as a violation of the Fifth Amendment. This brings me to my next point. Introducing Ms. Young's silence at trial violates her Fifth Amendment by effectively compelling her to testify. If an individual is clearly invoking the right to remain silent and choose to remain silent, and the arresting officer is later able to introduce that silence to prove an essential element of the crime, the Fifth Amendment loses any teeth and becomes nothing more than a illusory promise of protection.
But it's hard to say she was making a conscious choice to remain silent because nobody had told her that she had that choice to make. It wasn't as if the government stepped in and said, "Okay, now you can talk or you can remain silent." She just chose on her own not to say anything in response to the officer's questions after the first few.
Your Honor, this court has established, especially in light of the decision in the United States versus Dickerson, that the Miranda warnings are part of the national culture. People know them. People know that they have a right to not say anything to an officer. And this court has further held that the Miranda warnings are entitled to a liberal application. Therefore, because Ms. Young had... Thank you.
Okay, counsel. Thank you. Mr. Zepnick?
Good evening. Chief Justice, Your Honors, may it please the Court. My name is Nicholas Sepnick, and I represent the petitioner, Ms. Emily Young, in this matter before you. In my time before the Court, I will address the second issue and explain that the application of amended sentencing guidelines violates the ex post facto clause. Accordingly, petitioners respectfully urge this Court to reverse the decision of the 14th Circuit and remand this issue for resentencing for three reasons. First, the ex post facto clause is implicated by the application of amended sentencing guidelines. Second, the ex post facto clause is violated by the application of amended sentencing guidelines. And finally, the sentencing guidelines in this case should be mandatory. This Court should refuse to extend its holding in United States v. Booker to the facts of this case. Turning to my first point, the ex post facto clause applies to amended sentencing guidelines for two reasons. First, the guidelines carry the weight and effect of law, and further, the application of the amended guidelines implicates the purpose of the ex post facto clause. Foremost, the guidelines here carry the weight and effect of law. As the Fourth Circuit noted in United States v. Lewis, sentencing judges must calculate the appropriate sentencing range. This is not an easy task. This is a task that requires careful, meticulous computation, one that requires consideration of a number of factors, different guidelines, and different weighings to make sure that the sentencing judge calculates that sentence exactly.
Isn't that a basic problem in saying that these things are the equivalent of mandatory? There are so many things to consider, and any two reasonable judges could probably come to different conclusions on some of the enhancements that are applied. So the person who's committing the crime has no idea not only what's going to apply to his crime, whether he has someone with him, whether he brandishes a gun, whether he does this or that, and he's also not going to know which judge is going to be doing the calculations. And that can vary dramatically. And then, of course, they're not binding.
Your Honor, your question raises 3 points. First, the sentencing judge in any particular case must calculate the range specifically. While there is some discretion in whether certain exceptions apply, there is one appropriate range for any given case.
But it's a range, so it's not a set amount of years or months. It's a range. And I don't know how you can then argue that there is a set amount, and as Judge Crabb said, that these other variables a judge must consider won't impact that, and two judges looking at this in two different ways come up with different numbers in that range.
Yes, Your Honor. It is true that sentencing judges could consider different factors differently. Importantly, however, the guideline range at issue in this case in 2002 was between 121 and 151 months, as the record indicates on page 13. Petitioners assert that Ms. Young could have calculated that range at the time she attempted to cross the border. In 2002, at that time, this court had not determined United States versus Booker, and the guidelines then were mandatory. Sentencing judges could only depart for specific reasons.
Well, it's certainly hard to argue that if you didn't know that something was worse than it actually turned out to be, you were prejudiced. Now, clearly, as it worked out, she got a slightly higher sentence in this case because the judge used the new guidelines. But technically, realistically, being sentenced under a mandatory scheme and being sentenced under a discretionary one, it's a much better deal.
Your Honor, petitioner asserts that in this case, the guideline range here should be mandatory. As this case shows, there are instances where upwardly amended guidelines can influence sentencing judges. This case shows, as the record indicates on page 17, that the sentencing judge was influenced by the amendment and sentenced petitioner to 10 more months as a result of the amendment. Here, had the court followed the guidelines, which in 2002 were mandatory, petitioner would have received likely at most 151 months, which was within, at the upper end, albeit, of that original 2002 guideline range. There are notice concerns in this case. As Your Honor noted, in 2002, petitioner could have calculated her range specifically, not necessarily her exact sentence within the month or even within a year, but she could have calculated the 121 to 151 month range and would, at that time, likely have received a sentence within that range. Here, Your Honors, the ex post facto clause is implicated.
But not necessarily. The judge at that point might have said, you know, this is such a heinous crime that you committed that I am going to depart upward.
Your Honor, it is true that the sentencing judge could depart upward if
Even under a mandatory scheme.
Yes, Your Honor. If she found that there was some factor not contemplated by the Sentencing Commission in that instance, an upward departure is possible, though petitioner asserts not likely. And there are notice concerns here. Petitioner does not assert that there is a certain range. However, in this case, she could have calculated the likely range that she would have received, but she was sentenced under this amended range. That leads me to my second point. Petitioner in this case was subject to a substantial risk of an increased sentence. As this court stated in Garner v. Jones, petitioner must come forth with a substantial risk of an increased sentence to violate the ex post facto clause. Here, Your Honors, this is not a case of a substantial risk of an increased sentence. This is an actual harm. As the record indicates on page 17, petitioner was sentenced to 10 more months than the sentencing judge would have had he been influenced by the 2002 guidelines. This is an actual case, one before this court where the sentencing judge admitted what influenced his decision. He admitted that in this case he sentenced petitioner to an increased sentence as a result of the amendment. This is not a substantial risk, but an actual harm. This guideline amendment at issue here further implicates cases beyond petitioners. In the words of the Sentencing Commission, the guideline amendment here will keep sentences for pills involving 10 milligrams the same and increase, in the words of the Sentencing Commission, punishments for all other dosages of oxycodone. According to the FDA, Oxycontin is available between 10 and 160 milligrams. Those are the dosages available. According to the DEA, 40 milligram pills are the ones most involved in drug cases. Therefore, because only at the minimum level, the 10 milligram dosage, will the sentences remain the same, and here, in all other instances, Your Honors, the sentence, in the words of the Sentencing Commission, will increase. Those punishments will be higher. Therefore, Your Honors,
Well, you simply can't get away from the fact that the judge was not obligated to sentence Ms. Young within that range. He or she had complete discretion not to sentence her within that range.
Your Honor, petitioner asserts that in this case, the 2002 guidelines should have been mandatory on the sentencing judge. Such a distinction is not inconsistent.
Wait a minute, you're saying that the sentencing judge should have ignored the Booker decision?
No, Your Honor. Petitioner asserts that such a distinction is not inconsistent with this court's determination in United States v. Booker. There, this court dealt with a specific issue. This court addressed mandatory sentencing guidelines with judicially determined facts. Under those circumstances, the Sixth Amendment was implicated. A citizens' right to a trial by jury. Those facts are simply not implicated here. Here, the jury determined all issues of fact, and therefore, the Sixth Amendment is not implicated by this case. As this court stated in Rescue Army versus the City of Los Angeles, this court refuses to formulate constitutional holdings broader than that which is required by the specific facts of that case. The case of Booker involved two things: mandatory guidelines and judicially determined facts. Petitioner asserts that where a judge does judicially determine facts, those cases, the guidelines should be advisory. Here, however, where the jury determines all issues of fact, the sentencing guidelines should be mandatory. The minority in Booker considered this very issue. It brought this issue to the court. There, the minority...
So you're arguing based on the minority position in Booker.
Your Honor,
Usually not the approach one takes.
Your Honor, the minority approach in Booker did not fully support this distinction. The minority approach in Booker did support the fact that the majority's opinion was a sweeping remedy, in the words of the minority. But the minority's approach did not contemplate having mandatory guidelines where the jury determines facts and advisory guidelines where the judge determines facts.
Why do you think it isn't just sensible to say, as long as a person gets a sentence that's within the statutory maximum, there's been no ex post facto violation? The person, if we indulge in this myth that before you go out to rob a bank, you look at the statutes and see how much it is.
How much time you're going to get.
Yeah, right.
And calculate the guidelines, the guideline rate.
Well, let's just say you look at the statute, and it says you can get 5 years if you rob a bank or whatever. We indulge in that myth. The person comes in and he's sentenced under the guidelines and he gets 52 months. But he maybe would have gotten 47 if it had been a different judge or a different application of the guidelines. He knows exactly what he's going to get when he comes in because he knows he could get as much as a 6-year sentence or 5-year sentence. Well, it just doesn't make sense to me that we fool around with these, well, maybe you should get another month or 2 more months or a shorter sentence.
Your Honor, in your hypothetical, the criminal in that case knew the statutory maximum. Similarly, the criminal in that case could have calculated the sentencing range specifically, especially before this court's determination in United States versus Booker, as petitioner could have done in this case. Further, Your Honor, under petitioner's assertion of mandatory guidelines, criminals are able to calculate that range and make an educated determination about whether to actually engage in the criminal behavior. In conclusion, this court should reverse the decision of the 14th Circuit for 3 reasons. The application of amended guidelines implicates the ex post facto clause. The application of guidelines violates the ex post facto clause because it does not, in this case, pose a substantial risk, but an actual harm. Finally, this court should hold that the guidelines at issue here are mandatory. Petitioner should have been sentenced under the 2002 guidelines to a maximum of 151 months. Thank you.
Thank you. Mr. Mayo?
Chief Justice, may it please the Court. My name is Kyle Mayo, and I, along with my co-counsel, Susan Bronco, represent the respondent, the United States of America. I will be arguing that the use of Ms. Young's pre-Miranda silence did not violate her Fifth Amendment rights. Ms. Bronco will be arguing that the use of the sentencing guideline amendments did not trigger the ex post facto clause. This Court should affirm the 14th Circuit for 2 reasons. First, the use of Ms. Young's pre-Miranda silence at the border crossing did not trigger or violate her Fifth Amendment rights. And second, even if this court were to determine that Officer Hale's statements were inadmissible, those statements were harmless beyond a reasonable doubt. To my first point, the text of the Constitution states that no person shall be compelled in a criminal case to be a witness against oneself. The operative word in that clause is compelled. In this case, Ms. Young was not compelled to do anything.
Well, opposing counsel makes the argument, which I think is a strong argument, that when you appear at a border crossing and present yourself for admission, you become subject to a form of custody. Now, you're not in jail, but you're definitely not free to leave. And so, and furthermore, you can be searched completely. The Fourth Amendment, it isn't true that it doesn't apply, but it applies in a very much reduced form, and the assumption is that you are there and you better answer the questions that they ask you. If you don't answer those questions, you're going to have a real problem getting into the country, not to mention staying out of jail. So it is very much something very much akin to a custody arrangement.
Your Honor, it's the government's position that while Ms. Young was seized while she was talking to Officer Hale, it did not rise to the level of custody. And based on the factors that this court has used in the past, including the number of officers present, whether weapons were displayed, the location, and the duration, the government contends that all those factors weigh in favor of the government.
Do you think she would have, felt free to leave?
She may not have been free to leave, Your Honor, but that is only one factor in the determination. In this case, Ms. Young only had one Border Patrol agent talking to her during the entire time that she was with Officer Hale. No weapon was displayed by Officer Hale at any time, and the duration was not unreasonable for someone that was coming into this country. When a person comes into the country through the border, they must understand that there are steps that need to be taken to protect the borders, and it was not an unreasonable amount of time for Ms. Young to be held at the border crossing.
But she didn't really make a statement. You said something about she made a statement. She was silent, as I recall from the record, both pre-arrest and then after she was arrested and read her Miranda rights.
Yes, Your Honor. The statements at issue were Officer Hale's statements to Ms. Young and his observations after he made those statements. Well,
they're not the statements at issue.
That's the point.
Those are the statements, Your Honor, that the lower court or lower counsel objected to being admitted to evidence. Were Officer Hale's statements.
But they were admitted to show that she, for the purpose of indicating that she didn't say anything.
Yes, Your Honor. It was admitted to show that she did not. But at that point, Ms. Young didn't have a right to remain silent. People in the United States don't always, at all times, have the right to remain silent when talking to the police. A good example is when a person is being asked for identification. That person must give the identification to the police officer. They don't have a right not to give that identification. And in this case, Ms. Young did answer Officer Hale's routine questions. She answered why she was coming across the border and the routine questions.
But he didn't ask her questions later. He just made comment, wow, that's a lot of piñatas. That's not a question.
No, Your Honor, it's not. And that's why it's the government's position that Ms. Young was never under interrogation at the border crossing, and therefore Miranda rights were not triggered. Because in order for Miranda rights to be triggered, you must have both custody and interrogation. And there was no interrogation at either the first border crossing stop or at the secondary stop. So even if this court were to determine, and the government will concede that Ms. Young was in custody when she was taken to the secondary inspection point, there was no interrogation there. And so Miranda rights were not triggered. In order for the court to determine that Ms. Young was under interrogation, this court has determined in Rhode Island v. Innis that that is either express questioning or words or actions on behalf of the officer that the officer should have reasonably believed would elicit a criminal response. In this case, Officer Hale did not believe that that would elicit a criminal response. He was making an offhand comment, and as he indicated in his testimony in the record on page 6, it started out as a friendly chat with Ms. Young when she came to the border crossing. And so Ms. Young was never in custody and under interrogation for Miranda purposes in this case. The Second Circuit in United States v. Silva has held that Miranda rights are not required at the border until the suspect is under a custodial interrogation and it is clear that that is going to a criminal prosecution. And again, Ms. Young was never under interrogation in this case. In United States v. Frazier, the Eighth Circuit found that an arrest by itself is not governmental action that would implicitly induce a defendant to remain silent. And in that case, that circuit allowed the defendant's pre-arrest, pre-Miranda silence to be introduced as substantive evidence in the criminal trial. Even if this court were to determine that Ms. Young was in custody, again, she was not under interrogation. At the secondary inspection point, Officer Hale made no statements to Ms. Young that would indicate a question. The only statement he made to Ms. Young was asking her to please step out of the car because she was being placed under arrest. After she was placed under arrest, Officer Hale did his duty, took her into the border crossing station and read her Miranda rights, because that is when her Miranda rights attached in this case. In United States v. Riviera, the 11th Circuit held that a government arrest is not implicit of compulsion. In that case, officers from the Nebraska State Patrol pulled over a U-Haul and found boxes containing pseudoephedrine. The officers had the suspects arrested, and at trial, the officers testified that during arrest, those suspects remained silent, did not look agitated, and did not look confrontational. In that case, the court allowed that testimony because the defendants were not being compelled to say anything, as was the case here. Border crossings are unique situations. They are not like traffic stops. They're not like Terry stops.
And exactly the kinds of questions that were asked here are asked in the way in which they were asked here. I mean, their Border Patrol agents are chatty. They chat you up, and that is a form of interrogation. They're trying to get you to say something because that provides them with information. So the questions are never the third degree of the sort that you'd associate with a formal police interrogation, but they are clearly trying to obtain information, and they do it in a very friendly and formal way where the whole point of it is to get you to say something.
Your Honor, the questions that Officer Hale asked Ms. Young were routine questions, and this court has allowed under Miranda for police officers, when they first arrive at a scene, to ask routine questions before reading the Miranda rights. And after that point, Officer Hale did not ask any more questions. He made an offhand comment. That's the only objection.
That's my point, though. These offhand comments are a form of questioning.
It's the government's position that that was not, that Officer Hale did not reasonably believe that that would elicit a criminal response. Ms. Young could have given a completely innocent response to that if she would have liked to.
Or she could have remained silent, which is what she did.
Yes, Your Honor, she did. But at that point, if she would have responded, that statement also could have been admitted at trial. And so,
Could have and would have.
Right.
correct, Your Honor. And that's why in this case, at that point, that silence was not protected. The government was allowed to use that silence because it was not yet triggered Miranda rights. But even if this court were to determine that Ms. Young was, or that Officer Hale's statements were inadmissible, those statements were harmless beyond a reasonable doubt. In United States v. Hernandez, the Ninth Circuit outlined 3 factors to help a court determine whether an error was harmless beyond a reasonable doubt. The factors are the number of statements made, whether the silence was stressed to the jury, and the weight of the other evidence. In this case, all 3 factors relate to the government's position.
What did the silence go to? To her intent? To her knowledge?
As the record is incomplete as to exactly what the silence was.
Well, but, we have to assume what the significance, in order to decide this case, we have to decide what was the significance of the silence in terms of the way this trial would have taken place. In order to, you're the one who's arguing harmlessness. That's a record-intensive inquiry. So you have to have some way of saying what these questions were or what her silence was probative of. So what are we talking about? Probative of intent? Probative of knowledge?
Partially to intent and knowledge, Your Honor, but also the prosecution did not directly ask Officer Hale about Ms. Young's silence or about Ms. Young's demeanor. They asked another question, and Officer Hale then commented on it. It only took place 5 times, which goes to the first factor, 5 times only during Officer Hale's direct testimony. The second factor of the...
Do we know what the government said in closing?
No, Your Honor, the record does not indicate that the government ever brought up the silence again. There's no record to show that the government did bring it up during closing arguments, and the government would presume that that would have been objected to as well and been on the record for the lower court judge. So the government contends that the counsel below only referred to it during Officer Hale's direct testimony. The third factor is the weight of the other evidence against Ms. Young. In this case, there is a tremendous amount of other evidence. Ms. Young was found to be in possession of 40,000 pills. Ms. Young could have had 1 pill and been found guilty in this case. She did not have a...
But if the piñatas were something she bought for a birthday party and she got home and opened them up like the lady in Green Bay that opened her vacuum cleaner and found it was packed with cocaine, she could have been innocent. Just because she was carrying it if she didn't know what was in those piñatas.
Yes, Your Honor, that does happen, but under the model jury instructions, a jury is allowed to infer from other evidence the knowledge and intent element.
What was the other evidence?
The evidence of her evasive answers to Officer Hale's first statements that she was only traveling across the border for a drive that made Officer Hale suspicious because in his 17 years on the border crossing, that's not something that you normally hear. It's not a routine thing for people to merely go across the border for just a drive because of the intenseness of the border crossing and the time that it takes to cross the border. Further, Ms. Young had 40,000 pills in the piñatas. That's the other evidence that she was found in possession of those pills. And so the government contends that the jury could have inferred and reasonably did infer from that other evidence that Ms. Young did have the intent and knowledge.
But it was crucial that she didn't put up, she didn't have any other explanation to offer. I think it's pretty hard to say that would be a harmless error. Sure, she was in possession, and most people would think, well, if you're in possession of something, but there are stories upon stories of people that buy things that turn out to be packed with narcotics. And sometimes they know about it, but sometimes they don't.
Yes, sure. Again, that is a possibility, but the government believes that in this case, with this jury, the jury would have still found Ms. Young guilty of trafficking drugs without these statements from Officer Hale. The rule that the government is asking for today continues the balancing that this court did in Miranda versus Arizona of individual liberties and the needs and necessity of the police to be able to effectively do their job. The police need to be able to protect our borders. Especially in this time, the protection of the borders is an important issue. And for those reasons, we ask this court to affirm the 14th Circuit. Thank you.
Thank you.
Thank you, counsel.
Ms. Barranco?
Chief Justice, and may it please the court, my name is Susan Barranco, and I also represent the United States of America. As my co-counsel indicated, I will be discussing the federal sentencing issue, requiring this court to interpret the Constitution's prohibition against ex post facto laws. This court has called ex post facto laws many things throughout the years, Your Honors, but never anything but laws. Congress has not passed a law in this case that is ex post facto, and therefore that clause is not implicated. For 2 reasons, this court should affirm the 14th Circuit, which upheld District Court Judge Swan's substantively reasonable sentence below. First, federal sentencing guidelines and amendments to them are not laws. And second, application of Amendment 657 as well as Booker to the petitioner was neither unexpected nor indefensible because petitioner knew her conduct was criminal when she committed it. First, petitioner seeks a rule that would represent a vast departure from the purposes of the ex post facto clause. This clause is intended to restrain legislatures. In the court's decision of Mistretta versus United States, this court upheld the constitutionality of the Sentencing Commission itself by finding that Congress had not overdelegated authority it alone possesses to make legislation. That finding is thrown into question by a holding today that the Sentencing Commission does possess the power to legislate. Mistretta's holding is complemented by this court's holding in Booker, finding that guidelines do not have the force and effect of law. But it's another thing to state that the Sentencing Commission has the power to legislate, which they don't.
But we are told, and we have said, that what matters in an assessment of this is the practical impact of what is happening. And the practical impact of what happens at a federal sentencing is that the judge has to compute, is required to compute what guideline sentence would be. And that's the place at which he or she starts.
Correct.
And so, and this particular judge, did us a favor by saying, not you perhaps, but us, that we would not have, my sentence here is longer than it would have been had I proceeded under the original guidelines. So we know that the change in the guidelines, he told us, it had an effect on his sentence. And we're supposed to take a practical look at this.
Right, Your Honor, but practical effects it's a one-way door. We look at the practical effects of how these guidelines are used rather than whether offenders ever even take a look at them. And given the complexity of the sentencing table and the drug table that must be looked at alongside the sentencing table in a case like this one, it seems highly unlikely that an offender would consult the guidelines to determine whether whether crime pays. And it's the position of the United States that the holding in Mistretta is called into question by finding that the Sentencing Commission has the authority to legislate. And Booker merely complements this by finding that in no context, unlike petitioner's assertion, in no context can these guidelines be given mandatory effect. That's because of the Sixth Amendment rights that petitioner rightly notes are protected. And here, Booker, it should be noted, is offender protective. When you look at whether there's an ex post facto violation, you look at whether there's something retrospective, ex post facto, after the fact, and whether it is detrimental to the offender. But here, if Booker is what petitioner hangs her hat on, Booker is offender protective. It's protecting offenders' Sixth Amendment rights. And further, Amendment 657 represents the Commission's attempt to fix an irrationality in the sentencing guidelines.
You know, this is an interesting point. Miller is the case that the federal judges looked at and said, "Oh, we can't." While Booker was still before Booker, the judges looked at Miller and said, "Well, Miller said that the Florida system had raised ex post facto concerns." And so the federal judges all said, "Well, we can't give a higher sentence if the sentencing guideline changed from the time the crime was committed until the time of sentencing." Mm-hmm. But wasn't Miller a legislative scheme rather than a commission scheme? And maybe we weren't so smart to follow Miller, because the arguments against considering an ex post facto problem, I think, are very compelling.
Indeed, but because of the fact that the guidelines were written as written were mandatory, it's not surprising that courts assume that ex post facto concerns were implicated. But Miller versus Florida is distinguishable in many respects. First, the Florida legislature had to act in order for the guidelines to become effective. Here, the guidelines are effective without congressional action. They are submitted to Congress, and they merely become effective in November of the year in which they are handed over to the congressional body. So the distinction is that there is no legislative act from which this court can analyze whether the legislature acted with malice or vindictiveness. And again, this gets back to why this claim represents a vast departure from the entire purpose of the ex post facto clause. They didn't have in mind Congress delegating authority to a body that is an expert body in sentencing and studies numerous statistics and numerous sentencing worksheets, every sentencing worksheet produced by federal courts, and puts a ton of effort into formulating these guidelines. That's not ex post facto. That's completely reasonable. And Congress found that it would foster irrationality in sentencing, the exact opposite of, in fact, of what it was trying to do, if the courts were required to rather than using the updated, using the outmoded language. These guidelines are tools that Congress intended always must be used at their sharpest. In other words, when the commission speaks, that advice is to be followed. And it's almost like when the genie can't get back in the bottle. You know, Judge Swan could have sentenced in the 5 years between the effective date of the guidelines and the time, or the 4 years between effective date and sentencing, he could have sentenced numerous offenders under these guidelines. But to require them to use the old guidance would be, in essence, a per se rule requiring the unreasonable. And what we hold judges to is reasonableness. So a judge...
Does it make a difference, Counselor, the fact here that the guidelines actually overlapped, albeit just a bit? Or would your argument be the same if the guidelines did not overlap at all and there was a significant disparity between the highest guideline sentence, advisory guideline sentence, at one level and the lowest at the other? So there was basically no overlap.
If there was a wide disparity, Your Honor, that would be caught in post-Booker reasonableness review. In short, all the concerns that petitioner asserts today can be caught up in that reasonableness review. That's what the Sentencing Reform Act was about, was providing meaningful appellate review of sentences. And so where there's a huge change and the judge applies the new guidelines that to such an extreme detriment, that may present not an ex post facto concern, but perhaps a concern under the standard reasonableness review that every sentence would go through. But sentencing guidelines are not laws. As this court found in Immigration Nationalization Services versus Chadha, Article I laws are the product of a single wrought and finely considered procedure that includes two things, bicameralism and presentment. In this case, as already previously stated, these guidelines are effective without the President's signature and even without congressional action. Therefore, they are not Article I laws that trigger ex post facto scrutiny. Congress, Your Honors, sets the minimums and maximums that apply to criminal action. Congress. And here, the jury conviction at page 12 of the record notes the congressional statutes that were laid out that said petitioner is subject to a 20-year maximum. That would have been alleged in the indictment, the complaint. That would have been, and that's probably what was read when the jury handed down their verdict. You are subject to a 20-year maximum. That maximum did not change between offense and sentencing. Though had it, there would have been surely an ex post facto concern had Judge Swan ignored that legal change. There is simply no retrospective legal change at issue here, aside from what are solely judicial changes. But this court has never, in any of its ex post facto decisions, found there to be an ex post facto law where the only change is of the judiciary. And as Mistretta notes, the commission is of the judiciary. Congress had identified a problem of disparate sentencing of the judiciary and had it solved within the judiciary. And judicial action alone does not trigger ex post facto scrutiny unless we're talking about the criminalizing of previously innocent conduct, which gets me to my second point. Application of Amendment 657 to petitioner was neither unexpected nor indefensible under this court's test in Bowie versus City of Columbia or and reiterated in Rogers versus Tennessee in the year 2000. That test, the due process style ex post facto concerns, are about void for vagueness legislation where a reasonable person should be permitted to know that his or her conduct is criminal before they act. And so that line of cases and that concern, that strand of ex post facto, that first of Calder versus Bulls categories, is protecting in due process and when the judiciary acts, as is the case here. But Ms. Young knew her conduct was criminal when she acted, and that conduct remained constant, as did its penalties between offense and sentencing. As this court noted in Irizarry versus United States, any expectation that a criminal defendant would receive a within guideline sentence did not survive Booker. And though the petitioner would like, in this case, for Booker not to apply, Booker is offender protective, so I'm sure his other clients would not enjoy such a rule. This court noted in Rita versus United States that as far as the law is concerned, judges could ignore the guidelines. In this post-Booker universe, that is the law. This is offender protective on the whole, to allow judges to make an individualized determination, as Rita requires them to do, based on the facts of the case, is offender protective. Offenders should want that. In fact, at the time after Booker was decided, it was more often the case that judges, when they would depart from the guidelines, though they would often sentence within these guidelines as they reflect a reasonable range, but when they would depart, Your Honors, they would depart below the range. So it is offender protective to reinstate the discretion of judges. Given the ex post facto laws, again, can take many forms, but all of them require some kind of legislative action. In this case, the legislative act was over in 1987 when these guidelines became effective, the same year as Miller versus Florida was decided. And Miller does not stand for the proposition that any sentencing guidelines, that a sentencing guidelines amendment created by a non-legislative source can trigger ex post facto scrutiny. It's not an automatic abuse of discretion for courts to consider what is ultimately more reasonable guidance. Guidelines provide a framework within which we are to analyze, and appellate courts analyze the exercise of discretion of sentencing courts. Given two reasonable constructions of a statute, in this case, the Sentencing Reform Act, this court should take that route. The petitioner has not met her burden to prove that there was a next post facto violation in this case. Under the parole decision that should, the Sentencing Reform Act was intended to replace the parole as we knew it. And in the parole context, this court did not hesitate to find that there was no ex post facto issue because of the fact that these are administrative guidance. This is administrative guidance, and this is not binding on any kind of lawmaking body. While this court has found that there is no categorical rules in the ex post facto context, there's no mathematical formula of what's worse than not. To the extent there is a talismanic formula, it is the requirement of a legislative act. And here, it was completely reasonable for Judge Swan to have found that because Booker is no longer mandatory, as stated on page 18 of the record, that he could sentence as he saw reasonable. The sentence was 3 months over the maximum range in under the 2002 guidelines, which were not binding on Judge Swan. The ex post facto clause, its purpose is not to allow offenders to predict their penalties with precision. The fact remains that when petitioner unfortunately was convicted, she faced the exact same penalty that she could have faced in the post-Booker universe. Given the complexity of sentencing guidelines, there is no way that the petitioner can stand here and argue that the ability to predict the sentence is what drove her to commit the crime or not. For these reasons, because there was no Fifth Amendment violation here, and because there was no sentencing constitutional error, we would ask this court to affirm the 14th Circuit. Thank you.
Thank you.
Your Honors, petitioners have 2 points on rebuttal. First, with regards to the Miranda and Fifth Amendment issue, respondent's argument simply worships form over function. Interrogation issues in Miranda are very rarely clear. Indeed, the entire area of Miranda law takes place in a murky area of the law. Officer Hale was a seasoned veteran. He had 17 years of experience on the force. He had presumably seen it all and heard it all. He knew exactly what he couldn't do and what he could do. This is the most problematic situation. The standard offered by the respondent allows constitutional protections to turn on the subtlety and skill of the questioner. If nothing more, respondent's contention simply sentences the Fifth Amendment and Miranda warnings to death by 1,000 cuts. With regards to the ex post facto issue, contrary to the respondent's contention, this court has subjected mandates to ex post facto review as it did with the parole regulations at issue in Garner v. Jones. Second, importantly, as respondent concedes the guidelines were originally mandatory, the Senate voted 85-3 in favor of mandatory guidelines. The guidelines were completely mandatory in 2002. Finally, the discretion identified by the respondent may be offender protective. This is a curious contention in this case. Petitioner received a longer sentence as a result of the amendment.
Petitioner received a longer sentence, so probably doesn't appreciate the protective qualities of it.
Right.
Thank you, Your Honor.
Thank you. All right. The court will be in recess briefly.
All rise.
While they are doing the math, we have been invited to comment on the performances and the pluses and the minuses of the oral arguments that we observed. Nothing personal, just highly professional. And since I'm the senior judge, I'm asking the junior judge to go first.
I knew that was going to happen.
Yeah.
Do you want to go one at a time for each person, and then
You can do however you want to do it.
okay? I just wanted to say that I thought, Matthew, you did a nice job on answering the questions. You spoke very clearly, and I found that you were easy to listen to, so there really wasn't a problem with that. I thought you had a tough argument to make in some respects, but that you handled the questions very well. You answered them as opposed to, I've done this before sometimes, and not necessarily at Marquette, where somebody says, Judge, I'll get back to that. Nobody did that. And you were very articulate in the answers. Some of the analysis I had a little difficulty following. But I thought that overall you did a nice job, and this was not an easy, in my opinion, an easy position to have to defend. So,
Have anything you want to add with respect to Matthew?
With respect to Matthew, I think that you certainly had a sympathetic argument, because it is clear that when people arrive at the border, they are not exactly free to leave. But it was a difficult one to try to show that the custodial aspects of it rose to the level that it would mean that anything that she said, or the fact that she didn't say anything, would be admissible at trial. I think maybe some of our questions got you off point, and I apologize for that if that's what happened, but that's good experience. Judges do that to people. They ask questions, and the lawyers, I'm sure, say, oh my gosh, what
planet is she
of, and
from?
why should I waste my time? And this judge is really off track, and it's going to be hard to bring that person back and get them to my point of view. But I would agree that you have a lot of poise, and you're a very, very polished speaker, and clearly you were extremely well prepared.
I agree with basically with what's been said. You got bogged down in your argument, and you had a problem getting back to what you were going to say. You let us get you off the track, which was, at least it seemed to me that you did. that's very hard. That's a skill that's very difficult to acquire. It takes a lot of time to answer a judge who keeps dogging you, and then says, and then get back to what you were going to do. So, fortunately, you didn't lose your cool, and you were poised all the way through, and you have a very good speaking voice. So it worked out. That worked out. I mean, I think that was a plus. I think that the merit position you took is a real tough sell, because I can tell you that at the border, if you ever took the position that because this was a compelled environment, which it is, definitely, that you're going to have to give Miranda warnings once things get beyond the who are you and where are you going. It would shut it down. I mean, it would really be it just isn't done. So you're talking about a major change in the law. So, okay, and Nicholas.
Nicholas, I thought also that your style was very good and very pleasant to listen to. You seem to have, a good knowledge of your position. I had, and you also answered the questions. I think for each one of you, I think that was something that really impressed me. Is that, if somebody asked you a question, if it was difficult, you answered it or tried to answer it, and then you got back to your argument. I had a problem with the statement that the sentencing guidelines should be mandatory. I didn't hear in this case when you said it the first time, and that sort of took me by surprise. You may very well have said that. And that may have been good for your position, but I was having difficulty following that argument, as it were. But other than, you certainly seem to be very familiar with the facts in the case, and overall, I thought you did a nice job as well. Again, it was not an easy argument to make. That was somehow I think you guys got the tougher
short end of the
right.
stick.
But I understand you do change around. So maybe at other levels you've had the better arguments to make. Nicholas, and I think this would apply to Matthew as well, you both have an air of comfort about you when you're standing at the lectern. You may be very nervous, but you don't show it. You look very confident about what you're doing, and that is a wonderful thing in the courtroom. It makes judges more comfortable. It certainly makes the jury more comfortable, because they're so ill at ease. This is the first time they've ever been in this setting. They don't know what's expected of them. When they see lawyers that seem confident and cool and very comfortable about themselves, it is a nice thing, and they tend to listen more carefully and probably trust that lawyer to not mislead them about what's being said. So I keep going in the direction that you're going.
And I don't really have anything to add to that. You move through, and the argument you were making had a little something crazy about it, but but I'll give you credit that you move right through it when it got particularly crazy. Nothing like being poised while crazy.
And if you're going to be a lawyer, there are going to be arguments you're going to be making because your clients want you to,
or because you have to, or whatever. But so
got to work with what you got.
That's right. Now about Kyle.
Kyle, I thought you also had a very nice presentation and answered questions. I don't know why I'm obsessed about people answering questions, but it's very helpful, and it'll be helpful in a trial setting or anywhere else to really be very forthright and ask, address what the judge is asking, and then be able to go back to your argument without ending up in left field somewhere. You also have a very nice style. Actually, I was told you're all second years, and that's quite impressive, I might add. Very impressive, as a matter of fact. And so I think you've did a good job as well. I had problems with the silence issue or non-silence issue because the statements weren't really, they weren't really there was some question that went in it, as our chief judge said, that, just chatting can be a type of interrogation as well. But I think you handled those questions and, got through your argument, got back to it as you needed to do.
And I thought you did a great job. And you had the easier position, but I thought you were very well prepared, and you had a good sense of what it was that you were arguing about. And there is that sympathy for the position of the petitioner, that she was really not in the freest situation she could have ever been in. And you do think, well, it doesn't seem fair. And I think all of us have some question about using someone's silence as substantive evidence in a case. That just, your first thought is, it doesn't seem quite right. But you argued it very well.
Yeah, I agree. I really don't have anything to add. You a very smooth argument. It went well.
Susan, I thought you did a very, very fine job. You had knowledge of the cases, your argument. You were able to go back and forth. We didn't ask you as many questions. I don't think we were tired, but
No.
I think you got away with a little less questioning by us. But I thought that you clearly knew the law. You were able to cite the law. You were able to cite the holdings of the cases. If I had any criticism, it would be that you have a tendency to do what I do a lot, and that is speak too fast. And when I used to do trial work, I would write down on the closing or an opening, I would write across the top, slow down, because you get in the rhythm, and as you get in your arguments, that's just my problem. So, but it's something to remember. I don't think Judge Crabb agreed with me, but maybe my brain doesn't work quite as fast. But you made some points that I was trying to understand, and then you were on to something else. But I thought you really did an exceptionally fine job. And one other thing I forgot with you, Matthew, and that is you did the rebuttal. And I thought you did it very nicely. You had two things you wanted to say. You said them.
Sat down.
And you sat down. And it was very well done.
I always say I'm going to give a prize to a lawyer that says, I have just one more question. Yet to have to give that prize away. So the fact that you could say, I have two things, and you said two things, and you excellent. I didn't think you went too fast, but I think Judge Gorens makes a good point, because you want people to be following what you have to say, and if they're not real familiar with what you're saying, I think we all were, because we deal with this every day. But if you're talking to a jury or to people that, if you'd been talking to us about international law, we would have needed it a lot slower. But I thought I was very impressed with, it's rare to see somebody who's in such command of her material as you were. I felt we could have asked you any question we could have thought of on this subject, and you would have been right back. I was really very impressed.
Yeah, I think you did speak too fast, and you are very intense. And the combination of very intense and very fast, it does prevent the judge from thinking through to some extent what you're saying, which is why you didn't get as many questions, as we were staggering, trying to figure out, what did she. And then you were on to the next point. So you do need to slow down. But you had a terrific grasp of the material, which is what counts, and you're articulate. So, I think it was a super performance. Just slow down a little. Okay. All right. We are in a position to announce, is it appropriate? Okay. Not a minute too soon. The winning team is Kyle Mayo and Susan Barranco.